Hey guys, so a surprising update on the Even Klein TED Entertainment versus Kaceytron. Now, Kaceytron has been very vocal, and her case is now ahead because of Kansas City. So, depending on where your jurisdiction is, it controls a lot, like scheduling, what type of rules of conduct have to be applied, whether or not they really push arbitration and mediation versus going to trial. Where you actually get sued is one of the primary factors in determining if you can win. And that's why one of the first things they teach in law school is you battle over venue. You battle over jurisdiction. You battle over which court is going to hold your case. So here we see an update. Order setting deadline for filing of joint proposed scheduling order and for Rule 26F conference. So even though her response, Kaceytron's response, was one day behind the response from Denims, and even though Denims is kind of ahead of her by a few days, they have the same law firm. It looks like this court in Kansas City wants this case to go faster. So they seem to be more responsive here. No motion filed before the scheduling conference relieves the parties from compliance with the terms and provisions of this order. Any motion that does not comply with the page limitations set forth in LR 7.0 shall, unless be filed with leave of court, be stricken by the record. Counsel should be aware that the court expects adherence to these principles by attorneys appearing in their division. Further, the court believes it is to be in the interest of all concerns for the parties to be aware of the court's expectation. To that end, counsel shall forward a copy of the principles to all clients involved in this action. The other big part about this lawsuit is the lawyers for Kaceytron, the main lawyers, I assume they're main lawyers, they're not from Missouri. So they're going to be told this is our standard. You guys may not have practiced law, or you do not practice law frequently in Kansas City, but this is what we expect from you. Please behave. The parties are asked to call the conference line. Probably need to blur that conference line out. The parties shall file a joint proposed scheduling order discovery plan by September 23rd, 2025. Plaintiff's counsel shall take the lead in preparing the proposed plan. The proposed plan shall comply with local rules. The proposed plan shall state that the anticipated length of trial and whether the case will be tried to court. It is expected that the deadline for completing discovery will not exceed 180 days from the last defendant was served unless extended by court for good cause. Pursuant to federal rules of civil procedure, the proposed plan shall address any concerns or issues relating to electronically stored information, if applicable. So this is kind of the rules of engagement. And we're seeing that maybe Kaceytron, let me go back to see when this was. So on August 18th, so they didn't wait. So the answer, Kaceytron's answer was on August 15th. Her response or answer to the complaint was on August 15th, asking for a jury demand. And I believe Denims' response or answer to complaint was August 14th. But there has been no movement on the Denims case because it's in Los Angeles, where maybe the courts are more clogged. Los Angeles might be a very busy court system because they are such a large city. Here, what has happened is very important for both Denims and Kaceytron. Again, they say exactly the same law firm, because what you would expect that Denims would be the first one to go to court may not be true, because the court has decided we want to get this over with. Let's do it. So on August 22nd, there was a notice of filing mediation and assessment program reminder. Your designation of mediator is due soon, filed as a ADR event in CMECF. See notice of inclusion and a map general order for specifics. So the court is reminding them, hey, you guys need to get a mediator and let's try to mediate this out. Again, courts in different jurisdictions are going to have different timelines, which makes sense. So even though I do believe Denims and Kaceytron wanted Denims to go first. That's why the responses were a day separated, with Denims going first. But now, because of the court system, Kaceytron's going to go first. It is obvious that the court, and based on what they're saying here, and there's also a standard in Kansas City that may not exist in Los Angeles for the lawyers and the clients and how they're going to react to this content. It's very fascinating to see two cases with almost identical plaintiffs and what the court is doing. What tiny changes, in this case, it's venue and jurisdiction, which isn't that tiny, but in terms of YouTube, it might be. We'll see how Kansas City treats it differently than Los Angeles. We'll see how Missouri treats it different than California. And I'm thinking, so this is the principles of civility. Civility and professionalism is essential to the operation of our legal system, and this goal can only be achieved when all participants, lawyers, judges, court personnel, litigants, etc., adhere to the principles of civility and professionalism. Communicate professionally and respectfully. Consideration should be given to the nature and tone of all communications, including phone calls, written letters, as well as electronic media, emails, text, and social media outlets. There you go. This one will be about social media. Never deceive another. The principle is not intended to restrict aggressive expression of opinion helpful to a client, but is directed against the affirmative misrepresentations by lawyers. Honor promises and commitments. The principle seeks to avoid a cavalier attitude towards breaking commitments without good cause. A lawyer's word is a bond upon which others rightfully rely. Respect others' time, schedule, and resources. Lawyers should work cooperatively in scheduling all matters, considering the time commitment, schedule, resources, and well-being. Avoid unfounded and unreasonable attacks on lawyers and the judiciary. So this is a big one, right? I mean, this is a big one. Lawyers are trying their best to defend their clients. You have to give them leeway. And I think this is pretty important. Respect the well-being of yourself and others. The reason they're saying this is there is going to be a battle on social media. There already is a battle on social media where you're trying to get the public to agree with you, the public to side with you, not necessarily the courts. And I think in this particular thing, because it's not Los Angeles, it's not the Hollywood and the bright lights there. This is kind of a big social media case for Kansas City, right? But in Los Angeles, it's just like, whatever, right? Like celebrities get sued all the time. So this is Frogan. There has been no updates on Frogan. Frogan is way, way behind the rest. Even I would say 60 to 90 days behind, exactly, somewhere around that range. But I didn't expect Kaceytron to be first to bat, right? So it's kind of like they got their baseball team together. The lineup is Denims, Kaceytron, and then all the way in back, batting like last is Frogan, right? But now they switched up their hitters, and you might be like, oh, well, what does it matter? Well, ask a baseball team if you switch up the lead hitter, does it matter? Yeah, it matters a lot. In fact, some people would say it could win or lose you the game. So here we have and again, this is actually August 5th, so there's been no updates. This is our good friend Denims. There's been no updates on her. So even though Kaceytron filed later, or the lawsuit was filed later, and even though Kaceytron responded a day later, C is going to be the first one to do this court process. Now, I don't know if any of them go to trial, but if they go to trial, C's on the fast pass. It does not look like this court wants to take that much more time. So this is, again, the response on the 14th, and there's been no updates since that time. Kaceytron responded on the 15th, and there's been two major updates, including the request for mediation. Anyway, let me know what you guys think in the comments below. Bye, guys.